Welcome to the Global Migration Centre Lecture Series podcasts. You are about to listen to the recording of The Rights of Refugees Under International Law. It's a conversation between Professor James Hathaway and Professor Vincent Chetail. If you wish to keep informed about our activities, check out our website on graduateinstitute.ch/GMC or connect with us on Twitter, Facebook and LinkedIn.
It's my great pleasure today to have with us James Hathaway as the first speaker of the event series of this new academic year. I do not think that there is a need to introduce Professor James Hathaway, but to respect the protocol, James Hathaway is a professor of law at Michigan University and clearly a leading authority on international refugee law. His work is regularly cited by quotes and scholars. He is also the founding director of Michigan's program in refugee and asylum law and distinguished visiting professor of international refugee law at the University of Amsterdam, among many other appointments and activities. And Professor Hathaway is the author of many others in fact, but two reference books in the field of refugee law. The Law of Refugee Status, initially published in 1991 and with a new edition in 2014 with Michel Foster. And The Rights of Refugees Under International Law, published in 2005. And today we have the great honor and pleasure to discuss about the new edition of this leading book. You can see here the cover and the quite heavy, quite important number of pages. Of course, I mean, this is a reference book because of the content and not because of the number of pages. It is an authoritative book quoted by quotes, scholars, and international organizations since its very first publication in 2005. And there are many reasons why anyone interested in refugee law should read this book. First of all, this is a reference, a classic of the literature in refugee law. And I'm used to say to my students who are following my course on refugee law and who are willing to know more about this huge area, you should read three books: The Law of Refugee Status, The Rights of Refugees Under International Law, so the two key books written by James Hathaway, and also The Refugee in International Law from Guy and Jen McAdam. And in fact, it was also, the books I was used to read when I was a student. At that time, the literature was not like today with almost one new book on refugee law every week. And I had to struggle to have access and to find the paper copy of the first edition of the Law of Refugee Status from Hathaway. So I know his work since the very beginning of my work on refugee law, and I'm sure this is the case for all scholars, students working in this area. And this new book is particularly important and interesting for many reasons, not only because this is a reference book. There are many other reasons. There is a vital need to clarify and understand the rights of refugees in asylum states. First of all, because of the violations of the most basic rights of refugees in many parts of the world, with the rise of populism and xenophobia, but also because the traditional focus of legal scholarship is on the refugee definition to the detriment of the rights of refugees. So there is clearly here an important gap which is filled by this book. And also, among many other reasons, this is not only a doctrinal book. This book is also grounded on real practice. So this is both a doctrinal and empirical book as such. So it is helpful not only to know more about refugee law, to learn from the authoritative views of James Hathaway, but also for anyone willing to do research. I mean, this book is a huge source of many different sources and knowledge regarding to, I mean, thinking, but also regarding to the practice, case law, the drafting history also of the Geneva Convention. So this is clearly a must-read which has been recently published, the second edition. And I would like maybe to start the discussion with a very basic question addressed to, but basic at first sight. What are the main theses and the key messages of your book in this new edition?
Thank you, Vincent. And first, let me begin by thanking both you and the Graduate Institute for hosting us. It's very kind of you. And it's an interesting question. I mean, I guess if there is one core thesis, it's that the rights of refugees are best advanced by an amalgam of traditional international human rights law and refugee-specific norms. And that's what I think is perhaps unique about the book. It tries to draw both together in a consolidated paradigm so that basically the rights that could be advanced on behalf of refugees in any state party to the Refugee Convention or the covenants. And by the way, you know, as you would know, Vincent, it's quite extraordinary now that 98% of the world's refugees now live in countries bound by the covenants. And so not to integrate those two sources seems to me to be highly problematic if you're going to actually advocate for refugee protection. That's the most important thesis, I think, of the book. And the second, if I can, is I've tried really to focus on being quite rigorous about what the law is. I think far too much work in our field is wishful legal thinking, where we simply declare something rather than truly accept law with all of its limitations and constraints. And so what I've tried to do in the book is engaging not only all of the international case law, but the judgments from about 25 or 30 countries on refugee rights, and to show exactly what both the strengths and the weaknesses are and how one can overcome the weaknesses in a fairly black letter way. And this is not about what law might be in an ideal world. It's about what I believe law is and could be in response to real life predicaments. So those are the two core theses of the book, I think.
This is clearly, yes, the key net value of your book in order to be, I mean, to consider the refugee not only as a subject of protection by the specialized instrument adopted at Geneva in 1951 and amended, of course, by the protocol of 1967, but also, I mean, the refugee is protected not only as a refugee, but also as a human being through human rights law.
And it's kind of shocking to me that for many people that are siloed into one or the other of these areas, there hasn't been a lot of cross-fertilization. I mean, of course, one could go further still, right? Some refugees are women, some refugees are children, some refugees are racial minorities, and they have additional rights beyond this. And thankfully, we're now getting more and more scholarship that does take that up, which is fabulous. But what I've tried to do is really say, what is the common core? For the overwhelming majority of refugees in the world, there is this triptych of the Refugee Convention and the two covenants. And I've drawn on other materials more selectively. I mean, for example, in the book, unlike the first edition, there is treatment of the various regional refugee treaties that I think are becoming increasingly important. But still, the core of it is the triptych of the two covenants and the Refugee Convention itself.
Exactly. There is a need to go beyond the traditional silos, professional silos, and to understand refugee protection as a whole, because refugee law and human rights law finally are bound to work in tandem, because the same individual is governed by a broad variety of norms. And of course, by nature, human rights law is bound to be an important source to supplement the Refugee Convention, especially, and this is mentioned also in your book, the rights of refugees under international law. I mean, the added value, there are probably two key added value of this broad approach articulating refugee law and human rights law. First of all, as you highlight in your book, around nearly 43 states, UN member states are not parties, did not ratify the Refugee Convention. So here, human rights law is a vital source of protection because there is no specific specialized instrument. And second, for the state parties to both, and quite important number, you mentioned that almost all state parties to the Refugee Convention have ratified the two UN covenants. So, and here clearly, the Refugee Convention cannot be seen in isolation, in the sense that human rights law is also an important source for rights which are not governed by the refugee status and so on.
Absolutely. And on this one, let me return the compliment that you paid my work. I mean, your own work, Vincent, has been really helpful to me in pushing that latter thesis, the critical importance of the covenants and other specialized human rights documents. And actually, to add to that, I mean, one of the most serious deficits of the Refugee Convention is its lack of an international supervisory authority. That's a huge problem, which has been increasingly remedied by universal periodic review and specialized treaty bodies actually referring to the Refugee Convention in tandem with the actual treaties that they're charged with administering. And so to some extent, you know, we are getting within the UN system. And actually, may I say also, I've noted it particularly in the Latin American jurisprudence from the Inter-American Court, where they are drawing together refugee-specific and generic human rights in a synthesized fashion, in much the way that this book tries to really push for. So I think that is the new world. I mean, the tragedy is how few accessions we've had to the Refugee Convention over the last 10 or 15 years. It's just a part of the the UNHCR's mandate that has really not been pushed hard, in my view, and really is problematic. But given that deficit, given that's the world we live in, not focusing on the covenants and other specialized norms in tandem with the refugee treaty is pretty close to legal malpractice, I would say.
Right, and clearly, the crucial role of human rights law does not undermine refugee protection, on the contrary. And there is a need for specialist experts to articulate more systematically the different fields. I'm used to say that refugee lawyers must be human rights lawyers, because yes. The international law is so developed in many areas. We are working in isolation without attention to the broader picture and normative environment. And exactly. This is indeed not only for the sake of knowledge, but also, as you mentioned, because rights of refugees are under attack, there is also a need to clarify the added value of many other related branches of international law.
One of the earliest articles that I wrote when I still had hair was called Refugee Laws, Human Protection. And it was about, a lot of things we now take for granted, that persecution, for example, is defined by reference rights, etc. But the broader thesis was that this is, in my view, the single most important human rights has, it does grant particularized remedies to real people. It isn't just supervised at the level of abstraction by expert bodies. It actually provides real remedies on the ground every year for millions of people in a very hard and direct sense. And if we don't think of it in those terms and then marry it with the other norms that can be brought to bear, we do a real disservice to refugees. So again, part of the reason this book is so monstrous, I think Cambridge joked that it was the largest book it had ever published. I'm not sure that's quite true. But it's just when you do begin to draw those three treaties together, there is a mass of knowledge. And for judges and advocates and scholars not to be approaching it that way seems to me to be really missing the boat.
Mass of knowledge in this book, and also this allows to highlight the complexity and the nuances of this field, because too frequently commentators are used to have a very Manichaean picture about our field. Refugee protection is a complex area, and clearly the legal regime is complex too, because there are many conflicting driving forces. And that is why this is also, you have been able also to go in depth in the subtleties, complexities, while bringing a light and clarifying the issues, because it is too easy to be abscond and apparently complex. But what is important is to acknowledge the complexity and trying to clarify. And to me, this is the key, also another important element of your work. I would like to raise another question I have in mind for what, since the first edition, what is new in this second edition? What are the new topics, ideas, sources, of course, there are many things, but for those who didn't read yet your book, your second edition, what is new in this second edition? And are there some areas or issues where your thinking has evolved since the first edition?
Right. So this is a delicate balance with the second edition, right? Because part of what you want to do is enable your readers to operate comfortably with the framework that they've already become accustomed to since 2005. So I would say that 90% of the analytical structure is the same, and that was intentional. I did drop an early chapter on the history. It's now integrated into the various chapters, and I dropped what some refer to as the more political conclusion chapter on the absence of supervision and burden and responsibility sharing, but I've published a lot about that issue over the last 2 or 3 years. And I did that so that I could then add more content into the substantive chapters. One of the main new areas that I mentioned earlier that I have added is a whole section on each of the 5 regional refugee rights regimes. So there's at least an introduction to those and how they interact. One thing that I'm quite proud of, that I hope people will read, I think a lot of people just skip over it. Chapter 2, which is all about an interactive approach to treaty interpretation, has been pretty much completely rewritten. And in 50 pages, which is pretty tight for a thesis on treaty interpretation, I think, particularly for decision makers and advocates, it gives a pretty tight way, grounded in the reasoning primarily of the International Court of Justice, about how to push the Refugee Convention forward in ways that work in new realities. And I really hope people will read that. Beyond that, we've expanded a couple of the core chapters. On non-refoulement, for example, as one of my students joked, the chapter on non-refoulement is essentially a book. It's over 100 pages. And we've got specific sections on things like voluntary repatriation in international zones and protection elsewhere. Safe country of origin regimes are all taken up quite specifically. The other thing that I've really noticed being of critical importance lately is the issue of Article 31. penalization for unlawful arrival. And that chapter is also dramatically expanded, looking, for example, about a new framework of how to think about who gets the protection of Article 31 based on some really fine jurisprudence coming out of leading courts that has quite significantly simplified that regime. And maybe the last thing that I've tried to do more on is to talk about repatriation. Because again, it's an area where I think there is not a good understanding of what is actually allowed, and the rules have evolved fairly significantly. And it's important for us to understand that there is a thing called lawful mandated repatriation, that the voluntary repatriation framework of UNHCR is actually not embedded in the Refugee Convention. It binds the agency, but it doesn't bind states. And so I've tried to spell all of that out in an expanded chapter on rights of solution. I think those are the main things. I do want to flag one thing. There were a lot of critiques last time that the book is organized conceptually. It's not organized based on Article 1, Article 2, Article 3, Article 4. But we have this time included a table of concordance, which for those who are more comfortable looking up under Article 13, you can now quickly find all of that material, even though I've retained sort of the conceptual idea of working through the refugee journey as the organizing concept for the book, to help people understand both ways is now quite easy.
Excellent. Yes, indeed. And the structure is the same, but the content has been enriched considerably. I still regret as a reader the absence of conclusion, because I'm sure that is, the conclusion of the previous version was very inspiring. And but this is the liberty of the author to decide.
Well, it's actually the liberty of the publisher. The truth is, Cambridge, at a certain stage, what are we at? It's nearly 1,400 pages now. And one of the things that I actually, this sounds like promotion, and I don't mean it to be, but well, maybe I do actually. I was very, very insistent that the price be kept really low on this volume. This is probably the cheapest book that Cambridge has ever published in this size, because I want people who are actually doing refugee work on the ground to be able to buy it. So it's under $100, which is pretty extraordinary for this many pages. And so they did ride me hard in terms of the number of pages in the end. And I wasn't willing to sacrifice, the index is about 70 pages long, which is really, I think, critical. And I decided that was more important in the end, to have a really good index than for you to read here what I've published in the International Journal and elsewhere on the problems of supervision and burden sharing, which are legion, but maybe not as critical for this book.
And also the annex with the Refugee Convention, the Covenant, in order to allow also the reader to have, even if this is a quite heavy book, to have everything in hands. Clearly, is there a specific issue where your thinking has evolved, or do you think that this is more a consolidation and update to your previous edition?
Probably more the latter, Vincent, but I would say one of the areas which you would appreciate, and I'm sure many listeners appreciate, that has changed dramatically since 2005, is our understanding of jurisdiction. And the idea of jurisdiction, which is the linchpin for most of the really critical life-saving rights in the Refugee Treaty, I've been able to take a more aggressive position on that than I would have been able to do in 2005, because now, thanks to the International Court of Justice, the Inter-American Court, and particularly the European Court of Human Rights, we've got a much more robust understanding of when states take jurisdiction, and hence when at least those rights at the first level of attachment are applicable. So that one's been pretty significantly evolved in my thinking, thanks though to the evolution that law has undergone over the last 15 years.
And the part on the principle of non-refoulement is very substantial, very interesting, and
and so to give you, that's a good example, by the way. So the idea of that there is an exception to non-refoulement in the case of mass influx, that's been completely rewritten based on one of the Michigan colloquia that we ran a few years ago, where we imported the principle of necessity from international law as a way of circumscribing that discretion in a way that still gives states reasonable latitude to deal with a truly impossible situation, but which doesn't give them free rein to do whatever they want just because they call it a mass influx. So I have to say I'm quite proud of that chapter, but it came out of the work of, a dozen law students and as many contributing scholars, and I've drawn on that reasoning to, I think, really come up with a much better framework for mass influx than what I had in 2005.
Given the huge amount of documentation, sources from drafting history, soft law instruments, general comments, case law, and of course, huge literature which has been developed quite very quickly. What were the most difficult issues and challenges you encountered in writing this second edition? Because writing is also a long-term exercise and not an easy exercise, clearly. So what would
to be honest with you, I was my own worst enemy on this because, like the first edition, I decided I did not want this to be just a classic treatise that deals with law in the abstract. So you've alluded to this in your introduction. The case studies, there are more, I think there are a couple of thousand case studies here, and they drive the book. So I had a team of 10 undergraduate researchers working for about 3 years, plowing through every source possible to come up with possible examples of state practice consistent or inconsistent with the rights that would enable this book really to speak not in theoretical terms simply, but to actually say and to offer real conclusions. Therefore, when Ghana did this, it was or it wasn't in compliance. Therefore, when the United States did this, it failed to respect international law or complied with international law for these reasons. The hardest part was winnowing down, more than 10,000 examples into about 1,500 or 2,000 examples, weaving them into the chapters. Each chapter begins with an empirical study, and then linking all of the empirical back to the theoretical and historical so that you could actually see at the end of the day what the net result of the legal reasoning would be in a particular case. But by in a way, that was the hardest part. There's just nothing came close to that. And so, maybe I should have been a classic legal scholar and just stuck with doctrine, but this book just struck me as too important for that. I really wanted someone who was a UNHCR field worker or an NGO activist or a lawyer arguing a case to be able to say, this is how these rules actually relate to the hard facts of refugee protection on the ground. And so that was the hard part, Vincent.
Yes, and also the main added value, because with all these practical illustrations, clearly this is the main ambition of scholarship is not is to be useful and to help others, the city practitioners, scholars some scholars are convinced that they can change the world in their book. Our role is more modest than this, in the sense that we have to help those who are protecting refugees in giving them some basic source of knowledge, information, legal interpretation in order to be useful.
Right. And I don't want to pull any punches here. This is a normative book. I have a clear view that, refugee law in tandem with international human rights law should do justice to the dignity of refugees, people who are forced to flee their countries. And so it is true that, I take strong positions. For example, I've been criticized for having been a little hard on some judgments of the Court of Justice of the European Union in particular, where I think they strayed from the true meaning of the Refugee Convention and indeed of human rights law. So I think it is our job simultaneously to be honest about what all of these bodies have said, but not to stop there. I've always felt that my main job is to take a stand. And lots of people can disagree with me, but a scholar, if you're worthy of tenure, you should take a stand. You should take a position. And others can fight with you. And indeed, by the way, one of the joys of this book is that since I published the 2005 book, the Zimmerman commentary came out, and many of its scholars engaged my work. I, in turn, have engaged every one of them in this book. And, hopefully they will now return the favor in their next edition. This is exactly what we should be doing as scholars, is constantly pushing each other to see if we can improve the way that law functions to advance the rights of refugees, I think.
No, clearly, scholarship is a collective endeavor. We have all the same objective, but of course, scientific knowledge is about debates and collective work. Regarding the methodology you followed, so could you please tell us more about the methodology? Because this is both a doctrinal book, but also, with real impact. So there is clearly an empirical project, which is also mentioned in the introduction. And also the very interesting chapter on rules of interpretation. So for me, there are the two important elements informing the overall methodology. Real practice examples and a broader normative interpretative framework.
I think you've nailed it, actually. And I'm really delighted that you saw it that way, because what I wanted to do, and that's why I did insist on the importance of chapter 2, the interpretation chapter, I wanted to tell everybody right up front how I'm going to approach this, how I understand the rules of treaty interpretation, and why it is that I avoid sort of the wishful legal thinking approach to treaty interpretation. My essential thesis is you've got to be legally rigorous in order to be socially progressive. If those of us who are defending the rights of refugees obfuscate and exaggerate law, we don't do anybody a service, because the people that presumably we care most about will simply suffer when those arguments are rejected. So yes, we push law forward, but we have to do it in a way that has integrity and which is grounded in the principles of treaty interpretation of the Vienna Convention, as adumbrated by the authoritative courts. And so you're right, that's the first driver. But the second driver really is all of that empirical work. And so a lot of stuff that was in the first edition ended up on the cutting room floor, because I had spoken in the first edition to things that were no longer the big problems in 2021. And I replaced it. So literally each chapter, we wrote the empirical section first. And then I sat back and looked at all of the case law, all of the other materials that you've referenced, and thought about how they related to that series of examples. And so you'll see that every single empirical example, let's say, take the chapter on non-refoulement, there's a long exegesis of all the 101 ways that states are not respecting the principle. But then every single one of those is referenced somewhere in the doctrinal treatment. So it's not like acute introduction and then a legal section. The two are inextricably combined. Every single example is referenced in the doctrinal analysis of it, so that you can then begin to see that what I've tried to do is to have the real facts on the ground push the legal analysis and not the other way around.
Yeah, excellent. And there is a difficulty we all have, is this hiatus, this gap between the reality of asylum and the sources we have. The reality is that 90% of refugees in the world are hosted in the global south. contrary to the obsession of Western media, there is no invasion of the global north. Most refugees are still in the global south. And on the other hand, sources from the global south are quite difficult to be identified. You mentioned several ones from state practice, legislation, and so on. But there is a bias in our current sources regarding the case law. It's very difficult to find a case law, and this is not this is a fact, and it of course reflects the difficulties in our world to do a truly representative research on sources, and some sources are missing, and especially a case law from the global south. How did you manage this? Because this is a very concrete difficulty we all have. And of course, we can mention the African Convention, the Cartagena Declaration, but there is a need to have more access to the case law, because the case law does exist, of course. The fact is that the access is difficult. What is your experience with this?
So I think it's partly both. To some extent, in some places the case law doesn't exist, right? Because things simply haven't made their way to senior courts, and so that is a problem. But I think, I've struggled with this in the same way that everyone does, and including my African colleagues with whom I've regularly spoken. It's not just that Northerners can't find it. Southerners can't draw on it either, to the extent that it doesn't exist. But I would just say that compared to the 2005 volume, there is, for example, in Africa, obviously the courts in South Africa are all over this issue and have actually been more helpful than many courts in the developed North. But also the courts of Kenya, for example, have gotten deeply involved and conceptually involved in ways that are extraordinary. I was working in Kenya a few years ago and was shocked to find that one of the things that every single Kenyan judge at any court level, a family court judge must do is a basic course in refugee law. It's obligatory for every judge in Kenya, and they use it. And so I've tried to draw very heavily, particularly on those two African jurisdictions. In Latin America, the Inter-American Court is not to be poo-pooed. Right? It has really figured refugee law out over the last 15 years in ways that I've also been able to draw on. But, once you get into East Asia, it becomes harder. Yes, the Indian courts have drawn on international law through the back door, but East Asia, it remains tough. Papua New Guinea, for example, has issued some critical judgments that are in the book, but there aren't as many. And I've drawn on everything that I could find, and I want to maybe take this opportunity to thank the incredible network of scholars and activists around the world who have fed me cases over the last 20 years, many of which have ended up in this book that, as you say, I wouldn't have known about had people not been so generous.
The content of your book, The Rights of Refugees Under International Law, what are for you the main added values of the refugee status under the Geneva Convention? What are because it is critical to highlight that refugees are deserving protection as refugees, as a particular specific group of concern in needs of protection. But regarding the content of the Refugee Convention, what are the main added values for you?
Well, that's a big question. But look, I would say it is particularly valuable on socioeconomic rights. That's where the value of the Refugee Convention is extraordinary. So, for example, the obvious one is, Article 2.3 of the Economic Covenant would theoretically allow developing states to decide to what extent they want to grant economic rights to non-nationals. That would be devastating for 3/4 of the world's refugees. The the Refugee Convention contains no such provision. Economic rights under the covenant are all duties of progressive implementation. They are not duties of progressive implementation under the Refugee Treaty. And perhaps most important, there's a lot more specificity. So if you take something like the right to work, which is still fairly vague in international human rights law, I mean, extraordinary specificity in the Refugee Treaty in terms of even things like self-employment, professional employment, that are binding norms. But to be honest, even on the civil and political side, I think there's huge value because all you get under the civil and political covenant is an entitlement as a non-citizen to the various rights without discrimination. And when you dig down into the non-discrimination jurisprudence of the Human Rights Committee, it's actually pretty awful for non-citizens. The reasonableness notion, the margin of appreciation notion, the Refugee Convention has none of that potential for equivocation. There are rights there that are refugee specific, things like non-penalization for illegal entry, the ability to get identity documents, protection against refoulement, obviously, but there are also other things that are more subtle. For example, the civil and political covenant talks about fairness in judicial proceedings, but it doesn't talk about a right to get in front of a court in the first place, which the Refugee Convention does. And lastly, on the civil and political side, the covenant is subject to emergency derogation for the majority of its rights. The Refugee Convention isn't. And that's a big deal for refugees in a lot of difficult parts of the world. Extraordinarily limited derogation authority that ends once refugee status has been verified. No more derogation possible. So, I mean, that's a really short bullet. I've tried to set all of that out in the first chapter of the book. But the honest truth is that the covenants do not do the job that the combination of the two does. But similarly, neither does the Refugee Convention alone do the job that when you add in some of the developments under the covenants, you get with that merged notion of protection. So I don't want this to become a struggle between the human rights arguments and the refugee arguments. I mean, this is one happy family. And if we go back to where we were a few minutes ago, we see refugee law as human rights protection, then we ultimately understand that refugees have refugee rights and refugees have human rights because they're people. And the two are not in conflict with each other. You get both. And by the way, that's one of the things the Refugee Convention is so clear on. If there is a superior source of rights, you get the benefit of that. So it can't be used in a way that degrades the protection of the generic regime. It can only add to it, which is fabulous.
Clearly, I'm convinced that there is a cumulative application of refugee and human rights law, and not an exclusive application. But also, we should also acknowledge that human rights law has a lot to offer. In terms of substantive rights. I mean, there are many civil and political rights in the covenant, which are, and some basic ones, right to life, prohibition of torture, right to family life, protection of children, and so on. So clearly, there is a need to understand not only in competition, but there are today. We cannot think about refugee protection without the two elements.
Absolutely right. And again, I would say, if you were to push me on this, I would say the most important strength of the Refugee Convention relative to generic human rights law is on socioeconomic rights for some of the reasons I mentioned. And I agree with you that by and large on civil and political rights, taking away things like non-penalization for entry and non-refoulement, things that are specific, but there's no right to freedom of speech in the Refugee Convention, right? If you want that, you better. But on the other hand, here's an interesting one. There's actually a stronger right to freedom of religion in the Refugee Convention than in generic human rights law. So that includes effectively a duty of affirmative action to enable refugee minorities to reestablish their religion, which doesn't exist in generic human rights law. So, that's when I hope that when people read these chapters, I try to weave the two as seamlessly as I can so that the message that you're suggesting is sent, that these are not in competition. This is one catalog of rights that has three key sources in international human rights law that ought to be understood to work in harmony with each other. And again, you know, the UN treaty bodies, I think, are actually showing us how that can be done. They are increasingly drawing on refugee-specific norms to inform their interpretation of one or the other of the covenants. That's brilliant. That's exactly the way it should be done. In the same way that we've drawn on children's rights or women's rights or racial minority rights to inform the specific application of one of the two covenants. We do the same thing here.
And yes, they're clearly complementary and not mutually exclusive. Regarding economic and social rights, I will be more, nuanced than you, but we agree on the main conclusion, and we may have different ways to come to the conclusion, because the protocol on economic, social, and cultural rights, the core content is still applicable without progressive development.
Right.
And also the exception for developing country, in fact, has been never implemented. So we still can also consider that even in this area, even if it's true that for the right to work, clearly the Refugee Convention is stronger, but then they are more mutually reinforcing in the sense that the core content of economic social rights under the covenant is able to reinforce also the standards established by the Refugee Convention. And sometimes even I did a new rights, not only for civil and political rights, but also the right to cultural identity, protection of the family and children, equality between men and women.
I mean, there's no question about it. I guess if we disagree at all, I mean, I think Article 2.3, the exception for less developed states, remains much more important than many other people do. And I also think the core content idea, I mean, I first started talking about this in 1991. I remember Philip Alston being in the room, shocked that anybody was talking about an idea that had just been developed. But I think it's brilliant. But again, the core content is really only giving us what it says, right? There is a limited kernel of truth at the center of the right that is not to be abridged, but that leaves an awful lot of fungibility around the edges. What I'm saying is that, for example, if we just take the right to work, which is maybe the most important economic right, there is no comparison between the specificity of self-employment and professional employment and wage earning. The Refugee Convention offers all of that on top of what we get from the Economic Covenant. So I think when we've made the argument that, you know, the two are part of the same family, but each sometimes adds net value to the other, you know, this is where I would like us to end up. I don't want it to be a competition because there's no need for it to be. And when we think about it competitively, the only people who get hurt are refugees. Right? I mean, scholars can argue about how many angels on the head of a pin if we want, but at the end of the day, what we really care about is what happens to the people that the system is designed to protect. And now,
exactly.
In 1951, we've got this incredible array of human rights law to add on top of the Refugee Treaty. It hasn't supplanted it, in my view, at all, but I think it has added to it hugely.
So for you, and maybe to conclude, the Refugee Convention is still relevant 70 years after its adoption in 1951. And what do you, because to me, I think that the continuing relevance of the Refugee Convention is also intrinsically linked to the fact that human rights law has updated its content.
Sure.
Do you?
Yeah, I think that makes sense. And you know, the truth is, I mean, we talked about the fact that there have been virtually no new accessions to the Refugee Treaty over the last, 15 years or so. that, we all know that there are massive numbers of refugees living in states that have not signed the Refugee Convention, which creates a normative problem for us. The real difficulty there is the failure to adopt a binding system of global burden and responsibility sharing. I mean, poorer countries in the path of refugee flight are not going to sign on to the Refugee Treaty absent an insurance system provided by the rest of the international community. And I, quite frankly, wouldn't expect them to do so. This is a topic for another day, but, the whole non-binding rhetorical global compact route, I think, was a terrible mistake. And it explains why UNHCR has not been able to get any new countries to sign on, because they would be signing on to something that had unlimited liability and no guarantee of support. That's not viable. And the drafters of the convention knew it wasn't viable. They came up with, in my view, a brilliant definition, an extraordinary list of rights, but right in the preamble, they said, we need a system that enables states with confidence to know that burdens and responsibilities will be shared. And if there's a tragedy, it's that 70 years later, we haven't been able to make that happen. But I'll leave that topic for another day.
Okay. Now, clearly, this question is not governed as such by the Geneva Convention, and the Global Compact on Refugee is an attempt to address this in a non-binding form through cooperation, and we will see what will happen with also the refugee forum and so on, because of course, hard law and soft law are two different products with, but sometimes, on the long run, we will see if at the end, maybe soft law can make a difference or not. It's difficult to say right now.
You're more optimistic than me. And I guess it's partly because this is like the third time in my professional life that we've come up with this, principled political project to do this, and it just keeps being recycled. And quite frankly, I think that serves the interests both of many states and of the UNHCR and doesn't serve the interests of refugees. So I take a hard position on this one. We know what needs to be done. It's not complex. There are formulas out there for burden and responsibility sharing that have been tested. We should be moving on this. The idea that we ended up with yet another non-binding thing that creates lots of conversations and no duties is, I think, a real betrayal of refugees. We've been having these conversations for 70 years now. The time for action existed 2 years ago, and instead we came up with a talk shop. But again, I know reasonable people disagree on this. My view is that it was a real failure of imagination and will.
And you are also a key contribution to this area because you have firm positions about the importance of binding norms, the importance of the Refugee Convention. And again, scholarship is about debates, discussions, and we need some scholars like you highlighting what should be the way to be followed by states and so on. No, clearly, I would like to express my warmest thanks to James Hathaway for being here and discuss with us about refugee rights. Thank you very much. It was a great pleasure.
Well, thank you for having me, and thanks to everyone who contributed and listened in.
Thank you.